Messenger giant WhatsApp has told India's Supreme Court that it will fall in line. The platform has announced it will comply with the Competition Commission of India and refrain from sharing user data with other Meta-linked companies. In fact, this entire case against WhatsApp, it dates back to 2021 when it made data sharing with other Meta platforms a mandatory requirement to use its messaging service. Now, a probe in 2024 found that the company, it was abusing its dominant market position with a penalty of over $23 million imposed and a 5-year ban on data sharing. When the decision was challenged last year, that penalty against parent company Meta was upheld. Now, WhatsApp has withdrawn its appeal and has accepted the ultimatum handed down by India's Supreme Court, especially after it equated the policy to data theft and told the company to leave India or respect India or leave the country. In fact, joining us now is cyber law expert Prashant Mali. Mr. Mali, how do you look at this particular ruling? Does this ruling mark a turning point in India as a nation asserting sovereignty over global tech giants?
You rightly said it. India, see, if you look at the current AI revolution, there are 5 stacks. But the most important stack of this cake is the cream. And the cream is data. And India has too much amount of data, which everybody needs. Even the Meta company, Meta needs it. The ad tech industry needs it. The AI, LLMs, for the whole AI revolution, you need data. And India is giver of so much amount of data. And when we are giving them data, if they're not following the law of the land and they are killing competition, they are not following DPDPA, then such kind of action by the court will make them serious to look at India and Indians for their data.
Mr. Mali, for a country like ours, where WhatsApp, it is deeply embedded in our daily life, especially with the way we use WhatsApp, whether it is in offices, whether it is in schools, whether it is to communicate with our friends, etc. When the Supreme Court equates forced data sharing with data theft, how significant is that statement?
See, data theft is defined under Section 43B of the IT Act. And Section 43B of the IT Act says, anybody without the permission of the owner copies, downloads, or steals the data, it qualifies for punishment under Section 66, that is up to 3 years of imprisonment and 5 lakhs of penalty, plus above that, they can go for compensation and damages in crores. So India has a law, it is defined law, and as per the definition, when you're not taking the permission of the owner or the authorized person, it amounts to data theft.
Mr. Mali, from a cybersecurity perspective, does large-scale cross-platform data, pooling, does it create a sort of systemic vulnerabilities for India?
100%. See, even if today, let me tell you the status of the law in our country, which we completely will be activated possibly in the till next June of 2027. But even if we have that guardrail of our law, it still misses one point, and that is inference data. It misses another point, which is the AI weight. Weight is what AI is learning from the data we are giving them. So we may have assented to our personal data, but what AI has learned about us is, very opaque. So in such kind of cases, we are still lagging. Our inference data, looking at our various reels, what kind of things we are watching, what kind of things we are searching, when they make a personality or they make our profile, then that data is still outside the clutches of law.
Mr. Mali, would you say that India is right to treat user data as a national asset rather than just a commercial commodity?
Exactly. It is national asset because the personal data or PII belongs to the national citizens of India. So we can call it as a national data. And because of the data, if there is a harm or there is money earned out of it, then it amounts to national data.
Yeah. Mr. Mali, a final word from you. Many other platforms, especially the Telegram founder, Pavel Durov, he has previously criticized WhatsApp's encryption policy. He has called users brain dead to believe that the app is secure. How concerned should we be over Meta's privacy policies?
See, Meta's privacy policy is completely business oriented. It is not privacy oriented. It is made so that their business is enriched, maximum data is taken, and less privacy is provided. They want privacy to be lost in the pages of privacy policy. So their intention and attitude is an issue. Their intention and attitude is to, use the data and earn money. It's a very capitalistic thought. It is not equivalent to the law. It is not equivalent to what Indian socialist thought is there, where we have right to privacy under the constitution.
All right, Mr. Prashant Mali, thank you very much for speaking with RT India, and thank you very much for sharing your thoughts.
Thank you. Thank you.